All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in our case number SA23-0182, Rodriguez Ramirez versus State of Arizona. Counsel, we're recording and live streaming the argument, so please identify yourselves and your client at the beginning of your arguments. Each of you will have 20 minutes, but you're not obligated to use all that time. Appellant's counsel, you're responsible to watch the clock and reserve as much time as you desire for rebuttal. Please keep in mind, we've read the briefs, we've studied the documents and records provided to us, and have discussed the case in conference. As a preliminary matter, the court has noted that the motion to suppress, which was filed, I believe, on August, so I don't have the exact date, August 7th, it has not been provided to this court, and based on our review of the Superior Court docket, it is not available in the Superior Court docket. But it appears to us that it clearly was at least filed with the court, being that the judge said that she had it. So I'm looking to see if the parties would stipulate to file the motion to suppress in the Superior Court and then immediately file a copy with this court as well. Is there any disagreement with that? Okay. Okay. Counsel for appellant, you may proceed.
Good morning. May it please the court. Nicholas Bustamante on behalf of petitioner Rodriguez Ramirez. I'll be reserving 5 minutes for rebuttal. Your Honors, confessions are regularly suppressed to protect fundamental and statutory rights. This case is no different. This case is about, one, protecting the confidence that penitents have in their clergymen when they seek spiritual counsel, and two, preventing courts from ascribing a process for what spiritual counsel should take. This case deals with a known communication. It's not necessarily a novel issue. In fact, there's already existing case law that addresses this. It's in that framework was set out in Archibald v. Waters. Waters v. O'Connor did deal with a known email in the state's possession, and Archibald laid out the framework for how to assert the penitent privilege. That framework, again, is one, whether or not the confession was received by a clergyman, and two, whether it was received in his professional capacity, and three, whether or not that was received within a discipline enjoined by the church.
Counsel, what's your best argument that we've read the transcript that this is actually confessional in nature? It has a lot of hair on it that makes it seem non-confessional.
Judge, I would say that confessions are going to cover a whole swath of secular topics, and they're going to cover a range of advice. And the purpose of confession is, as Trammell was noted in Trammell and by the Supreme Court, is for people to disclose their worst moments to their clergymen. That's naturally going to be hairy. Ugly topics will be discussed, but the purpose is...
Like the discussion of leaving the state, for example. Those discussions. I mean, can something simultaneously be in the nature of abetting a crime and be confessional in nature at the same time?
One, I would dispute the fact that there was ever any suggestion to abet a crime, but there's already an exception to that. It would be a crime fraud exception. The state never litigated that, so that wouldn't apply here in this case. But to your more direct point of whether or not ugly topics are going to be concerned, such as was disclosed along with spiritual advice, yes, that's going to come up. The confessions are ugly. Again, we're dealing with people's worst moments. And the fact that the repentant process coverage a range of topics and discussion doesn't make it any less spiritual. Sorry, Judge, go ahead.
Sorry, can we reset the clock?
Because we seem to have 10.
Yeah, it should. They both should be 20 minutes. So sorry, I'm sorry.
No.
So sorry to interrupt. I should have caught that. Just take a minute.
Yeah,
sorry to go back. I wanted to circle back. I wanted to make sure you understood that it's the defendant's obligation to make that motion to suppress to get it filed as soon as possible. Okay,
we'll get that done after this morning's hearing, Judge.
Appreciate your patience here.
Okay.
Yeah. believe you had, I think you had about 3 minutes left. Is that right? Yeah. That'll work.
And then set the other.
Yeah, and then set the other side as well. All right, go ahead.
Okay, thank you, Judge.
Apologize.
The fact is that Archibald and Waters already have a framework to do this. The lower court just didn't apply existing case law. After the evidentiary hearing at the conclusion, there was nothing ever in dispute. This was a pastor. He testified that he received it in his spiritual capacity, and the penitent said that he went there to seek spiritual counsel. Now, that can be muddied by some of the facts in the conversation, but that doesn't make it any less spiritual. At the conclusion, there was nothing ever in dispute. The pastor also testified that there was a procedure to go about in the Arcadia Baptist Church for how they went about accepting confession, and that often took the form of a one-on-one conversation. That happened here. At the end of the evidentiary hearing, there was nothing in dispute. There's no reason for the lower court to misapply the law and impose a reasonableness analysis when there wasn't a justification to do that.
But counsel, our cases have talked about reasonableness within the context of privilege. Would you agree?
They would, Judge.
So it seems that when we're dealing with whether a privilege attaches, we may be talking about the subjective belief of the penitent and perhaps the priest, although it belongs to the penitent. And then whether or not the state as the opponent has overcome it, that it has to be objectively reasonable, that two people can't just sit and say, oh yeah, no, we think this is subject to a privilege, and be able to survive any challenge. There is some point where it's no longer, where it doesn't fall within the statute. And that seems to be the objective, reasonable side that the state needs to overcome. Defendant makes the prima facie showing, then the state has to overcome that presumption that it's privilege. Or do you see it differently?
There's a number of questions in that, but I think this may best be explained by going through what the petitioner suggests as a good test for this when you're dealing with a known communication, and that we can incorporate the three elements of Archibald into a prima facie case, and then it's incumbent on the state to show that there's a legitimate dispute. And then if you go to an evidentiary hearing, you would only use the communication to analyze and interrogate the circumstances surrounding the confession, but not the content of the confession itself. If you have to get to the content of the confession, we're asking that this court adopt AACJ's suggestion and that it be a wholly secular analysis.
It had to be
a wholly secular analysis. That way it prevents the courts from doing what they're not in the business of doing, from deciding how religious enough of a confession should be. But going to your question, I think you were alluding to Waters v. O'Connor and looking at the reasonableness of a confession. Waters didn't actually stand for that proposition. It was a reasonableness analysis to an objective element in that test, which is whether or not they were dealing with an actual clergyman. There, it was a music director who no one in the church ever saw was a clergyman. And to the extent that Waters suggested in passing dicta that a reasonableness analysis could be done, it was only where there was a dispute as to the laws and customs associated with that faith.
So let me ask you this, because it seems to me if we take your analysis, that anytime two co-pastors talk, they can always assert a privilege.
I think that it's not whenever they talk, Judge. I think that it's whenever they're giving spiritual counsel to one another. And here there was that, Judge.
But if they assert we were giving spiritual counsel, how do you ever overcome it?
In the context of a known communication, you would have to show that there was a dispute. If there was a crime fraud prevention, the state could assert that. But if you,
we can't look at the content. You just ask us not to look at the content.
I said, I think the suggestion is to look at the content. If at the evidentiary hearing you can question, because naturally, practically, how is this going to arise? The defendant is going to make an objection that something be withheld from evidence. They're going to submit a motion. The state's going to have the known communication. The communication is known, but you can't look at the content of the confession to assert the privilege. And Clemens v. Bernini made that very clear. You can't invade the privilege to prove that the.
So that's my point. You've got a known communication where all they did was talk about how much they were collecting this month and where they were going to put that money and how they were going to spend that money and all of those things, but they've asserted a privilege. But you're saying you can't look at that.
I think that you could look at it if at the evidentiary hearing, that, the circumstances surrounding it, let's say both pastors saying, hey, we're a pastor, this is privilege, that facially meets a prima facie case in Archibald. But if it's not clear to the court, then you could look at the content of the confession and analyze the content itself.
So when we get to the second phase,
Correct, Judge.
then that's right. And so, but is it an objective standard at that point?
At that point, it would be an objective standard for the point, but getting up to that point, it would be a subjective
Right.
analysis.
So the first part, do we have at least a prima facie privilege? Subjective.
Right, but what we don't want to do is to put courts in the position when they're assessing a confession, it's going to be objective because it's only going to focus on whether or not it was secular or non-secular. If it is wholly secular, then there's no privilege because they're not talking about religion. If they are in that conversation, in their confession, talking about spiritual counsel, then the privilege would attach. And that prevents the courts from ever having to assess the reasonableness of a confession.
So is the harm to the church seems rather non-secular, just like harm to a business. Or do we parse it out and say, well, some of these may be privileged and some may not, depending on it? Or is it all or nothing?
I think that you would look at the confession as a whole, Judge. I don't think that you can parse out, because realistically speaking, how do confessions work? You talk about a range of topics with your spiritual advisor. The court's not in the business of going through that and assessing which ones are protected or not. The only way you'd ever do that in an unknown communication is you'd get to an in-camera review, and it's in camera to protect any prejudice that would come from disclosing these communications. That's the same thing we're trying to do here, except that it's known. So we're saving it as a last resort for courts to look at the content of the confession.
We don't do anything like that in law generally. We don't say that when someone's testifying on the stand for 30 minutes, that when you waltz into something that's protected by any other privilege at the 15-minute mark, whoops, the whole thing becomes privilege, right? Because we subject the whole thing to a totality analysis. That's one of the things that I'm troubled by about this, is this seems like this is kind of like the unicorn thing in law where it gets expansiveness that nothing else does. And also I'm confused about how we give a wholly secular reading of whether or not someone is giving spiritual counsel. I mean, is it that seems to, your standard seems to enable pretextual uses of the privilege, right? Because you can just sprinkle in a reference to God here or there and be talking about, escaping jurisdictions and using prostitutes. But if you mention God, we're not supposed to look behind that. That's troubling to me.
Judge, I think that confessions cover a whole range of topics. Some of them are going to be, again, as has been noted by the Supreme Court, people's worst moments. That doesn't make them any less spiritual. The court.
Well, I guess how do we determine something spiritual when you tell us we have to not look at its content? That's really difficult for me to think about analytically.
I think analytically, it's not that difficult. You would look at the content of the confession and say, okay, are they talking about committing a tax fraud? And then are they praying throughout it on how to commit the tax fraud? That at some point, would not be spiritual. But if they're looking at it to, talk about, hey, I have this problem. I'm coming to you to talk about the problem, as was done here, then it is spiritual.
See, but the first thing you said was you look at the content of the confession. And it's like everything in these briefs is like, well, don't think about what's inside the box, but you started off and said you got to look in the box. And we can't analyze anything without looking at its content, really, can we?
Well, Judge, here, the box should have never been opened. The problem is that the box was open and given to the state because someone surreptitiously recorded a confession.
Well, that leads to a really fascinating issue, which admittedly no one has raised, about 4062, which is that 4062 says you can stop the clergyman from testifying. But does that also apply per force to an audio recording that is not the clergyman? Like, what if the clergyman never testifies and someone just tries to introduce the tape?
I think at that point, the tape, you would still file the same motion, get it to get a court to have it be inadmissible. Well, the test that what we're proposing is to prevent what the trial court did here. When there's nothing ever in dispute, when you hear credible testimony, as is noted by the trial court, but still come up with a test to assess the reasonableness of someone's confession. That would never happen. I mean, confessions in a Miranda violation context will tell you the worst things. As a criminal defense attorney, that's true. You're going to hear the worst things. The problem is we're here to protect the principle behind it, and that principle is to protect people's, one, confidence in their clergyman, and two, also protect someone's due process right to a fair trial. So for that reason, that we're suggesting that because it's a known communication, it would be a prima facie test first because the communication is already out there.
Counsel, let me jump in. What's your reading of the phrase professional character? How would you define that? No court, it doesn't appear, has really tried to explain that, do any statutory interpretation of that phrase? How do you view that phrase?
I would say you can judge it by the nature and circumstances surrounding their spiritual advice given. So if it's, and the trial court was right, and to one degree, it took issue with the fact that someone said that, a pastor can take their hat on and off when they want. That doesn't happen. I think the professional capacity of a spiritual advisor or clergyman is much broader, and it's going to depend on how they're interacting with their congregants. If a congregant, if you're at a church retreat, and you come up to your pastor, it's not at a church, it's at a park away from the church, and you say, "Hey, pastor, I really need to disclose something to you. Can we please step away from here and talk?" If that happens, at that point, both parties are understanding that the pastor is engaging in a spiritual exercise with the penitent. So it's going to depend on the nature and circumstances surrounding the confession.
But I'm just you have to acknowledge that co-pastors can take it off. It may be a unique circumstance, but we have two co-pastors here. They can take that hat on and off, and probably do pretty regularly. They
can judge, and but that would also go to the reasonableness and subjective belief of the penitent. Again, this is like the attorney-client privilege. It's an intent-driven analysis that focuses on the person seeking counsel. And despite one of the cases that the state cites, it's a Drellick, I believe it's a New York case. That case is distinguishable facially because the rabbi said time and time again, "I'm not acting as a rabbi. I'm not acting as a rabbi." That didn't happen here. You had credible testimony where Pastor Padron said, I was acting in my spiritual capacity.
But when they start talking about the impact on the church, that's really not about any kind of spiritual healing. They're worried about the church, the institution, not the individual. Doesn't that fall outside? Again, if we parse it out that it's not everything is covered.
Judge, it's the transcript, both of the pastors understood it as being spiritual. They spoke about this as being God's mission. They were engaged in the conversation and confession to find a solution to something. They spoke about it as being God's mission. Pastor Padron gave the petitioner advice on how to recounsel with his family, and that, he had
and perhaps engage other people for services. I mean, is that spiritual advice at that point?
I would say it may not be that particular excise comment may have not been, emanate from a chapter and verse of the Bible, but that doesn't make it any less spiritual. It's the exercise and the confidence that we're trying to protect.
I have a few seconds. I don't want to get into yours, but and Judge Jacobs mentioned totality of the circumstances. Is it totality of the circumstances that the state has to show? Is it by a preponderance of the evidence that it wasn't reasonable? What is the burden of proof or the test? Because totality of the circumstances isn't necessarily a burden of proof. They're different from preponderance. So what is it?
Yes, Judge. We're suggesting that it be a clear, convincing standard because of the intimate interest associated here.
Is there any case that's ever applied the clear and convincing standard? I couldn't find one, but I'm just wondering.
Not that the defense is aware of, but
okay.
There are cases that say that after a prima facie case has been met, it can be overcome by a clear and convincing standard. And then in the case that the state cites, Kent v. Bobby, they suggest a clear and convincing standard, but there was to terminate parental rights. But that court did say that because of the interests were so high that the standard to terminate parental rights had to be CCE. Here, the interests are equally high. We're dealing with one, a confidence someone has in their clergyman, and two, about protecting a free exercise. I'll say the rest of my time for
one quick question though. Finding 17, if I understand your argument correctly, there was also significant discussion about the church's management and administration. You're not arguing that's an abuse of discretion for her to find that. You're arguing it doesn't matter as a matter of law because it's mixed together with other legitimately spiritual things and the whole thing is covered, right? That's your position, right?
Judge, our position is that it was an abuse of discretion because under the dicta in Waters, there was never any reason to get into the reasonableness of someone's belief that they were engaging their penitent in their spiritual capacity.
No, that's a legal argument that it's irrelevant is what you just said, as I understand it. Are you saying it's factually incorrect that there was significant discussion about the church's management and administration? You don't disagree with that factually, do you?
No, Judge.
Okay. But I understand. I take your point. It's irrelevant from your framework.
Okay.
Thank you. Counsel for the state. Yes.
Good morning. May it please the court, Quentin Gregory for the Maricopa County Attorney's Office on behalf of the state of Arizona. And with me this morning is my bureau chief, Philip Garrow. If the defendant in this case is found not to have waived the clergy penitent privilege, or if the trial court is found to have erred by finding that he could not satisfy the second prong of the test, it's really difficult to imagine any case in which defendant statements to the clergy would ever be admissible at trial. In this case, after finding out from his brother that the defendant had molested his niece, the co-pastor Padron met with the defendant and opened the conversation with, "You know why I'm here." Regarding something that opposing counsel mentioned, the co-pastor Padron in fact testified at the evidentiary hearing multiple times on page 36 and 29 through 30, 53 through 54, that he met that day with the defendant as a friend.
Yeah, let me read to you footnote 5 in the court's ruling. It says, Pastor Padron's testimony that he believed the conversation was friendly and familiar and not in his capacity as a pastor, while credible, is irrelevant to this court's analysis. So the court, yes, I understand that he said that multiple times, that he was acting as a friend, but the court didn't rely on that.
And I agree with that statement. However, I do think that it is relevant in the limited sense that if we are looking to the subjective or objective perceptions of the defendant when he is having this conversation, the nature of the conversation and how co-pastor Padron is treating it, the things that they're discussing, that should key him in onto the fact that this is not a conversation that is in fact a confession, and that is in fact something that he can expect to be maintained. The confidence of that will be
initiated
maintained.
the conversation?
The testimony. So the defendant testified that he called co-pastor Padron to set up the meeting. Co-pastor Padron, I believe, testified to the opposite effect, or rather maybe that he couldn't recall, but that he was the one who wanted to have the meeting. And I would point the court's attention to the fact that the trial court here found that the defendant's testimony was not credible. And I think that that is a theme that runs throughout the court's order and should inform this court's analysis of the issue when it's conducting the test or reviewing the waiver claim.
Does the testimony show that the recorder was on the entire time during the conversation?
The testimony of the defendant is that they arrived at the park and he said in no uncertain terms, "This is a confidential conversation," and then the recording started. And the trial court again found that and the balance of the defendant's testimony not to be credible.
So 100% not credible.
100. I'm assuming, because the trial court's order is unequivocal, that the defendant was not a credible witness. So
do you disagree that there was at least a basis to go forward on subjective? The initial prima facie, that he established a subjective belief that there was a confidentiality?
I think that if the court adopted the standard set forth in Clements, looking first to the prima facie case, that the defendant likely established a prima facie case. However, it was done in sort of an odd procedural manner here. It was essentially in an email to the trial court saying, "We just found out that Padron is a co-pastor, and so we think that we may have a privilege issue." And then one of the briefs that the court is lacking, supplemental briefing was ordered that was filed the day of or the day before the evidentiary hearing started. And so the analysis here was sort of fast-tracked, because the fact is the recording was made on the day of the conversation and then immediately provided to the defendant's family and then provided to police. In addition to that, it was also provided to each member of the church, of which the two men were members of or pastors of. And the fact is that both parties had in their possession this recorded conversation and the Spanish to English transcript. And for 2 years, reviewing the contents of that conversation, it never occurred to anyone that this may have been a privileged conversation under the clergy penitent privilege. And I think that the fact that nobody recognized that for 2 years weighs heavily in favor of the court, of
But we're not-
upholding the court's order
We're not
regarding
here
the
to weigh
second
whether
prong.
counsel really did just learn of the co-pastor status. It would be hard to argue that in any other context,
Whether
if they
the-
didn't know that he was a co-pastor.
No, and the
So,
state doesn't
I mean, I
dispute that.
get your point, but I don't, so let me go back then to, once he established the prima facie case, what was the court looking at? The objective reasoning, reasonableness, and if it was objective, under a totality, under a preponderance, under clear and convincing?
So the trial court placed the burden on the state to prove that the privilege should be overcome. And that's implicit in the trial court's finding, because I think it's the very last paragraph, is that the state has met its burden. So the trial court placed the burden on the state. It's unclear what that burden was. It was at least a preponderance of the evidence. I think that the trial court
How do we
likely,
know that? Would
well,
it have been totality of the circumstances? Because it's not said either way.
it could have been. That's correct, Your Honor. And I think that the case that informs this the most, and assuming the trial court was following the law, which this court does, you look at the Waters case, where the court took the testified belief of the defendant that he thought he was communicating with a clergyman, or a clergywoman in that case, I believe, and then looked at the surrounding circumstances of that belief and the fact that he had a relationship for several years with that person and should have known that that person was not, in fact, a clergy person at that church. And I think that that is what informed the trial court's decision here.
But it doesn't tell us what burden or what she used.
The trial court's order does not.
So what are the alternatives? Totality is not a burden. There's preponderance of the evidence, which is 50% plus one. There's clear and convincing. Are there any other Arizona law burdens it could have been in a civil context to determine the application of a privilege, or criminal context?
Not that I'm aware of. And I think that it, in fairness, would be one of those two, whether it's a preponderance or clear and convincing. And the state argued in its supplemental brief that it should be clear and convincing. And that comes from looking at the objective language of the statute as it's written, Arizona's policy of disfavoring privileges in favor of the truth-seeking function of our courts, and admitting all testimony when permissible that does inform the jury or the finder of fact of the truth of the matter.
Does that same policy apply to attorney-client privileges?
The same disfavor?
Yes.
I think that the way that disfavor is written in case law, the policy is the same. However, the standard of attorney-client privileges is different. It's a four-pronged test, and there's been a lot more jurisprudence on that issue because it comes up a lot more than this. And so the boundaries of that have seemed to have been drawn a little more clearly.
Why would we do it differently? Why would we say that it's easier to pierce the priest penitent privilege or clergy penitent privilege than it is the attorney-client?
I don't know that it's necessarily easier. I think that if there is a difference in how those things are approached, it's in recognition of the difference of the relationships of the Sixth Amendment right and the 14th Amendment rights that give rise to the attorney-client privilege. Whereas here, while there are First Amendment implications in the clergy penitent privilege, the right itself, or the privilege itself rather, is one of common law. It's born of history and doesn't necessarily take its roots from the constitutional rights of a
But the clergy penitent gets to the Sixth Amendment too. I mean, it implicates the saying there's nothing special about attorney-client that gets to the Sixth Amendment. Or am I missing something?
I think that would just be the general right to counsel and effective counsel. And if everything that you say to your lawyer can be pierced by the state without some sort of
But your right to counsel has to do with the criminal case. What about, the attorney-client can apply to an attorney you had 10 years before you were charged criminally. It's not we're not talking about piercing the privilege to the attorney in the case. That's the right to counsel.
Well, that may be the case. However, I would note that the attorney-client privilege, all the privileges, professional privileges rather, are codified both in civil law and in the criminal code. And so There may be a difference in how the court treats those in different contexts.
But they're both there. The clergy penitent is there as well.
It is, and I don't have the cite to the civil law.
So, I mean, just because they argue we shouldn't look at the content of the conversation, and we shouldn't look at the nature of the advice. And it seems to me that to the extent this was some sort of ecclesiastical advice and some sort of confession, the co-pastor arguably would not have given what many people would consider good spiritual advice. Why didn't you use someone who had been sex trafficked? Why didn't you think about this? What about running? Does that break the privilege just because, and I'm just not going to say that this person was giving bad advice, but that this, if your priest is not very good or your attorney gives very bad advice, does that break it? Because that seems to be what you're arguing. Well, he really didn't say things that we'd accept, so we shouldn't have that apply.
I don't necessarily assert that the things that the non-holder of the privilege says in a conversation will always break the privilege. However, I do believe that it informs the analysis of the subjective or objective perception of the penitent in this case and what he perceived the conversation to be. A confession.
So I guess this is part of why I struggle. So is that under a totality of the circumstances as opposed to a preponderance of the evidence? In other words, is it a burden, or are we looking at something like the totality? Because that seems to be closer to what you're arguing.
And that may be the case. I think that the way that courts have handled this issue is that they do look at the totality of the circumstances. That's obvious in Waters, defining clergy. That's obvious in some of the foreign jurisdictions, the New York case, where the rabbi testified as to the secular practical things that they discussed and that the penitent there was seeking from him. The Calm case and the Nutter case in Massachusetts that talk about the secular nature of the conversation and how it was truly driven at avoiding the consequences of the defendant's actions there. And it wasn't seeking ministerial advice. It wasn't seeking what's been defined as a confession, which is an admission of guilt and a petition for forgiveness. There is, in fact, very little, if any, petition for admission of guilt and petition for forgiveness in this conversation. The balance.
But if there was no admission of guilt, nobody would be trying to admit an evidence.
Well, some admission.
So there is some admission of guilt. That's why the state wants to use it, right?
Yes, that's correct.
That
and
seems fair.
yeah, I misspoke. Thank you,
And what's the standard on that? Let's say you have a 90-minute interview, conversation, different denominations call it different things, confession, and about less than 5%, maybe even 2% of it deals with an actual confession. The rest might be very much secular topics or things that you wouldn't even call spiritual. Are you saying that it can't come in then? It seems like you're saying under the totality of the circumstances, it's 97 to 3%. It shouldn't come in.
What shouldn't? Any of the testimony.
I mean, anyway, the testimony should come in. The state would argue all of it should come in.
Correct. And
what's the justification, legal justification for that?
Well, the plain language of the statute applies only to confessions.
It says any confession.
Any confessions. And so that's true. And so there may be parts of the conversation that you can say, okay, the privilege would cover this if that is all that they talked about. However, if the balance of the conversation, and the state hasn't tried to argue the weight that the court should, or the exact balance as far as a percentage of confessional versus non-confessional material that would be dispositive here. But when the balance of the conversation is about things like, you know why I'm here, how could you do this? Our trust has been lost as friends for 30 years. We have to protect the church. We have to get you out of Arizona. You have to look out for your freedom. These are all quotes or paraphrases from that conversation. And in fact, most importantly, discussions about leaning on the victim's family to ensure that they don't go to the police to protect the defendant and to protect the church.
But the pastor is complicit in these comments. So it seems the pastor is making a lot of these comments, including the prostitution comment. So the pastor can defeat the privilege in that manner?
In the conversation, I think that it can, because what's relevant is the expectation of confidence that the defendant has in this conversation. And so when the conversation veers that way, the law expects him to know that this is not a conversation that he can expect to be confidential.
Even though the cat's out of the bag at that point, he's like, oops. I guess I shouldn't have come here.
Well, the
And I
fact
better
is,
stop talking.
the cat was out of the bag before the two men ever met, and both testified to that the co-pastor knew of the allegations against the defendant before they ever met. And so they met and they discussed these things, talked about, and yes, the state concedes that it was the co-pastor Padron who suggested, I'm going to go to my sister-in-law and I'm going to try and dissuade her from taking this to the authorities. And the defendant did not object to that. He said, okay, well, if it doesn't go our way, call me. And so he can know that it's time to leave Arizona before the authorities are alerted and he's arrested. And the privilege cannot be found to exist to protect conversations like that. That is using the privilege.
Let me ask you this then. It seems to me that at least at the very beginning, there was a certain amount of something most people would consider a privileged conversation, or at least some sort of confessional. I peeked, I hugged her, those kinds of things. So if it started that way, is the state willing to concede that at least at some part of this at the very beginning should be subject to it, and maybe it veered off, and that we should parse which parts actually come in? And again, that comes down to and I'm just going to, not again to suggest anything about anyone in this case, but can the clergy give really bad advice? Maybe you should go to Las Vegas. Think about taking off and disappearing to protect yourself. Can they do that and still have a privileged conversation? So that's two questions. First, and let's start with the first one. Didn't it start off in that priest or clergy penitent field?
It started off more innocuously, I would say, in that the parties were having a more mundane conversation that involved just the actions that the defendant had committed and confessed to. However, it did not proceed that way. It proceeded not with a petition for forgiveness and for spiritual guidance. It proceeded with a petition to help me get out of this. And that vitiates the privilege, and that's the state's position. And that you look, as Your Honor has suggested, you do look to the totality of the circumstances surrounding that conversation. And as suggested by the court in Waters, when determining the first prong, we look to the traditions of the church, and we look to whether the beliefs of the penitent were reasonable. Here, the same can be said for the second prong. When you are sitting there having a conversation with a lifelong friend who is also your brother-in-law, who is also the biological uncle of the victim, and then the conversation steers toward, we have to look out for your freedom, we have to, you may need to leave the state, and that may dissuade the family from going to the police if they know you're no longer here, then that informs the belief of the defendant whether or not the co-pastor is acting in his professional capacity as a spiritual leader, as a clergy.
Can't looking out for someone's freedom, looking out for their well-being also be part of the spiritual advice that's being given? I mean, I'm not certain that we can say, and again, it may be because under a totality it doesn't get there, or whatever standard ultimately comes out, but that those are things that people usually talk about. How do I get through this? What do I do? And maybe, again, the priest gives bad advice, but that doesn't break the privilege. And I'm asking you, how do we square that? Because that's a difficult piece to square for me.
Mm-hmm. I believe it's on page 7 of the state's supplemental brief that cites to the federal practice rules. I can't recall the exact secondary source, but it does in fact suggest that we look to the nature of the conversation as to inform the defendant's belief as to whether the privilege will apply. And so that suggests and then cites to various authorities throughout the country that when you are approached by the clergyman, or when you approach the clergyman and they are approaching you with animus and approaching you as an enemy and as a relative of the victim, that you cannot expect that conversation to be confidential. You cannot expect the privilege to protect you from the other person testifying about that conversation. And I would not suggest that the court should craft a rule that says anytime a preacher gives bad advice that the privilege doesn't apply. because we're not trying to say what spiritual guidance is, but in this case, it's very easy to say what it is not. And that is what the trial court found here.
Just one question. Didn't want to interrupt my colleagues, but I like that citation, and I agree with that citation as a statement of the law. But this was a confrontation call that was not disclosed as such to the object of the confrontation. And you admitted that it started off in a more neutral way, and you even said he confessed. You used the verb confess in your argument. And then later on, it becomes pretty clear, as the trial court found, that the church was behaving in essentially a church protective way, almost like a business would protect itself from scrutiny. Can that set of facts, can an undisclosed adversarial start, which it was, blooming into a more robust, like, we're just here to protect the church, sort of in a transactional way, can that vitiate the totality of it? Is that your position, and do you think it does? I might be able to accept that. I'm not sure this panel does. What's your view of that?
I believe it is in that source that I cited that says business conversations are in fact not covered by the privilege, and that's in a universe of other secular topics. That conversation alone, again, we're not suggesting that you take 20%, 80% and say, well, the privilege does or does not apply. So that conversation alone, in this case, because of the circumstances of the case, I would argue that it could vitiate the privilege, because protecting the church from the fallout of the defendant's actions necessarily involves subterfuge and covering up this crime. If they go to the police, like what happened here, then the church will find out about it. And so under the circumstances of this case, yes.
Counsel?
Yeah. Thank you, Your Honors.
Could you add 1 minute to time, please?
Your Honor, the state makes a lot of haste out of the relationship and the familial relationship that the pastor had with the penitent. Again, the trial court correctly found that it doesn't matter. In fact, the ACJ cited to a case, State v. Jackson, that shows in that case there was a mom who was also a pastor. The court's analysis there out of North Carolina just focused on the fact that they prayed together and that she was there to hear a confession. This dual role didn't matter because, in their opinion, it would vitiate the privilege. And that's exactly what it'll do here. In the attorney-client context, if I give one of my clients bad legal advice, that doesn't vitiate the privilege. And in fact, there's a remedy for that. It's ineffective assistance of counsel. Here, there is no remedy. The remedy is exclusion. This should have never been in the state's hand to begin with. The only reason it is because someone broke the privilege and treated it as a confrontation call, but luring them in under the guise of being a pastor. The pastor's deceit in this doesn't make the penitent's ability to assert the privilege any less powerful. And again, we're here to protect the underlying principle so that people can speak to their clergymen in confidence.
Is it objectively reasonable when you have a 13-year-old alleged crime victim to think you're reposing confidence in a confessional to the uncle of the alleged victim? Is that objectively reasonable?
I think it is reasonable for people to go to their clergymen and discuss their worst moments. I think that they're going there, and the conversation, if I give someone bad legal advice that objectively from another attorney would be unreasonable, again, there's a remedy for that. There's no remedy. And again, it's the purpose of the penitent went, in this case, to the pastor, was to seek counsel. And if he testified to that, the trial court found the pastor's testimony credible, but yet discounted the testimony of the penitent in this case.
What about his point about 2 years of not raising the aspect of it being confessional? Could you speak to that, please?
I don't think that matters. And really, from a trial posture, my understanding of the procedural history of this case is that, yeah, there was a communication, but it wasn't until the defense did interviews that the pastor said, hey, yeah, I was a pastor. I was acting as a pastor. That's what led to the impromptu objection and led to the evidentiary hearing. At the close of that evidentiary hearing, there was nothing ever in dispute. And the only reason that the judge looked into the reasonableness of someone's belief was because there was a disclosed communication that should have never been disclosed. Again, this court can look to the facts surrounding the conversation at an evidentiary hearing and use a confession to look at whether or not this person was actually a pastor, whether or not this person was actually a penitent, what church they work at, is it an actual church? Those are things that could happen at an evidentiary hearing. But we're saving, what we're trying to get this court to do is to prevent courts from assessing how religious enough a conversation is. And that's precisely what the state wants here. And that's exactly what the trial court did here. Trial courts are not situated to assess the validity of a religious practice or how religious a conversation is to merit protection. And it is for those reasons we're asking this court to vacate the lower court's ruling and find that Pastor Padron's surreptitious recording is inadmissible. Doing otherwise is going to invite distrust into the confessional practice and engender surveillance into the repentant process.
So I apologize for the redundant question, but since we haven't seen the motion to suppress, I'm asking you since we're all here. But so it's not just stopping Pastor Padron from testifying, it's also separately the physical reality of the tape. It's both. It's both, and to you, that's the same.
Yes, Judge.
Thank you.
Counsel, thank you both for your arguments this morning, and we'll take this matter under advisement and issue a decision in due course. We'll take a brief recess to prep for the next argument.